Hello, everyone. On behalf of the Visual Effects Society and the VES Tech Committee and my colleague Michele Scoletti, welcome to the Legalities of Gen AI. We're excited to bring this new topic, not new topic, but this new addition to our series on Gen AI. The Visual Effects Society represents one of the most legally complex creative communities of artists, engineers, IP owners, IP creators, and vendors, each navigating a patchwork of federal, state, and international copyright frameworks that were largely written after the kind of work we do started to exist. To help navigate this new evolving landscape, we've assembled a panel of leading experts I'm really excited to introduce to you, starting with Meeka Bondy, who is a media technology and IP transaction lawyer with focus on emerging technologies. Her career spans digital publishing, streaming transformation, and today's media landscape. Angela Dunning, she's based in New York. Angela Dunning is based in San Francisco, runs a Chambers recognized practice focused on generative AI, copyright, trademark, and technology litigation, handling some of the most high-profile cases today. Stephen Strauss, who's based in Los Angeles, has over 30 years in domestic and international trademark, copyright, and unfair competition law. He's prosecuted over 2,000 US and global trademark cases and represents top talent in creative content creators. Welcome, all of you, and thank you for making the time and lending your expertise today. With that, I'll hand it over to Angela Dunning.
Hi, thanks so much, Barbara. Oh, I think I froze there for a moment. Thank you so much to Visual Effects Society for having us. We're thrilled to give you an overview of where things stand today on some of the key issues affecting use of generative AI. I think we have a slide deck. We can go ahead and get that up. There we go. So thrilled to be with everyone. We're going to touch on a number of key issues that hopefully are on people's minds and be here to answer questions. But this is a quote that Stephen and I both really like. Any sufficiently advanced technology is indistinguishable from magic. That's true, and the magic is growing and changing, and the issues arising from that magic aren't going away anytime soon. Just very briefly, I know everyone is figuring out ways to use this in their work, but we're just going to show a few things. I mean, we know that generative AI is being used to make beautiful images. This image we'll talk about a little bit more was made using Midjourney and won an art award at the Colorado State Fair. Next slide. We've seen generative AI being used by independent artists to create truly a beautiful work that is very human and inspired in the way that art always has been. We're seeing it used to create short films, which receive copyright protection, and we'll talk about that. We're seeing it used in the real world. That image of the lychee styled chair is one that I invented and brought to life using DALL-E some time ago, but there's no reason that a company couldn't start making and selling that product today. I sort of want that in my house. And more importantly, we're seeing the technology being used in real life solutions involving cancer detection, disease identification, and therapy development. So these issues are, of course, much broader than the film industry and have wide-ranging repercussions and implications. And not all of them are good. We are seeing a variety of issues. Some of these issues emerged quite a while ago and are still being addressed, such as AI's proclivity to hallucinate or even overcorrect for bias. We are certainly very much aware of the opportunities to misuse it to affect elections. We are aware of real concerns arising out of use of AI in filmmaking and what that will mean for the people who have always made that effort possible. We are aware of public backlash around AI, and performers are concerned about how it's being used with and without their permission. And there's an awful lot of litigation. So I'm a litigator in the US. I handle cases. We are certainly not going to address all of these cases, but this slide is meant to shock and awe just a little bit to show just how much litigation is pending across the country. We'll talk about just a few of the cases that have actually emerged to some rulings. But it's far and wide and it's not going anywhere anytime soon. So what are we going to cover today? Well, I'm going to start with giving you an overview of the state of law on AI training and fair use. We will also talk about the really important issue of copyrightability, what you own and what you can protect when you incorporate AI generated content into your work, and what the risks are and the best practices there. And then we will also talk about other risks, including trademark infringement, making sure that we're staying on the right side of right of publicity and digital replicas laws that are, just coming online and are new and differ state to state. And we'll also touch on some of the key considerations around contracting and the practicalities of dealing with all of these different issues from the perspective of a studio, of a performer, of a creator. So I'm going to start on the copyright infringement piece and the training side. Copyright infringement at a high level is, occurs when somebody uses somebody else's work without permission under certain circumstances. So there's a set of rights that a copyright holder has and exclusively. Those include the right to reproduce the work, to copy it, to prepare derivative works, to distribute that work to others, to perform it and display it. And typically speaking, doing those things with somebody else's work will require permission, or it would be infringing. When we're talking about copies or making derivative works, nothing is infringing unless it's substantially similar in protected expression. The question is really, am I able to get the author's protected expression from the infringer, or is it have they made a new work that isn't actually substantially similar, in which case it would not be infringing. And a copyright doesn't cover everything in a work. This is an important point. It doesn't cover ideas or facts or information in a work. It doesn't cover style. It doesn't cover savoir faire, so standard themes or characters or storylines, and it doesn't cover things that have fallen into the public domain. It covers only the original protected expression, the way somebody expresses those ideas in a particular work. And then another key point is that making fair use, even without permission, is not copyright infringement. And so the AI cases that are being litigated now mostly turn on the question of whether training models is a fair use or instead infringing. So how do courts determine that? Well, there are 4 fair use factors that are built into the statute and the Copyright Act. Courts look at what was the purpose and character of the use. That's the first factor, and often considered one of the most important. Courts look at whether the use is transformative, meant to convey a new message or purpose, or instead sort of just copies the original. This transformativeness test is super important because our First Amendment protects the right of all of us to use somebody else's work, to comment on it or criticize it, or convey our own distinct message in form of parody or something else. And so courts really focus in on what is the purpose of this use? If it's to do something new, to convey a new message, then that's really going to weigh in favor of fair use. They also look at what the nature of the copyrighted work is, with sort of creative works being deemed, of greater worthy of greater protection than, say, a highly factual matter or a compilation of data. How much is being taken is another part of the analysis. And then finally, the other really important factor is, does the use that's being challenged cause substitutive harm in the market for the original? Well, what does that mean? Can I get the copyright owner's work from the infringer instead of the copyright owner? Am I going to go to the new challenged use as a substitute for the original? Because there are uses of people's work that will harm the market for that work. If the New York Times comes out with a scathing review of a book and they've quoted from that book, that may harm the market for that book and cause it not to sell. But that's not the kind of harm that is recognized. Instead, the kind of harm that's recognized is where you can get that content from somebody else. And application of these fair use factors really turns on context. So I've used this image before It's one I created using Midjourney. But, I think if somebody tried to put this image on T-shirts and sell them, you'd get a demand letter and a complaint both from Disney, who owns the copyright to the Snow White character, and Coca-Cola would have something to say about use of its trademark. But if instead this image was used to illustrate an article, criticizing the health hazards of sugared sodas and comparing that, to today's, modern poison apple, that probably would pass the fair use test. And it's the same image. And so how you interpret whether something constitutes fair use is really fact dependent. So how have courts applied these principles to the training of AI models? We have two decisions among that whole map of cases pending across the country. Only two have reached substantive decisions on fair use. Both of those were in the Northern District of California out of San Francisco. And I worked on the case against Meta, and I'm familiar intimately with the case against Anthropic. Both courts held that the use of books without permission to train a large language model, Claude in the case of Anthropic and Llama in the case of Meta, constituted fair use. The courts held that factor one, the nature of the use, weighed in favor of fair use because of the truly transformative nature of generative AI. The court in the Anthropic case held that AI is, quote, spectacularly transformative, and among the most transformative technology many of us will see in our lifetimes. And the court in the Kadri case against Meta agreed. I'll skip over the next couple of factors. They both found that they were creative works, and that the whole work was used, and that weighed slightly against fair use. But that didn't really change the equation in light of the transformativeness factor. And then the fourth factor, the courts diverged a bit. So Judge Alsup in the Anthropic case and Judge Chabria in the Meta case both held that there was no right to a license for use of works for AI training. So this part they agreed on. The plaintiffs had in both cases asserted that the harm they suffered by having their books used for training was that they were denied a license fee for that use. And the courts held that this would be circular, that given the transformative nature of the use, and the fact that it was fair, the plaintiffs did not have the right to monopolize the market to use the works for AI training or to demand a fee for that. Both courts evaluated and included in their analysis the fact that in neither case was there any evidence that either Claude or Llama were being used to generate outputs that looked like plaintiffs' books. That simply wasn't in evidence in either case. But where the courts diverged is with respect to what constitutes harm for that fourth factor. In the Anthropic case, the court held that the fact that AI can be used to generate lots of new works that could compete with the plaintiff's books was not a recognizable harm, because the Copyright Act is meant to encourage the creation of new content and new expression and competition, and couldn't be used to stifle competition in non-infringing outputs. Judge Chabria in the Meta case had a new take on this factor, and it acknowledged that it was a novel approach, but said that he would be willing to consider evidence that an AI model is creating so much competing content that it is diluting the market for certain authors' works and thereby harming their ability to sell. But he found that the plaintiffs had come forward with no evidence of that in our case. And as a result, both courts ruled that the use of books for training an LLM model would be fair as a matter of law. Well, Why do we then have a $1.5 billion settlement in the Anthropic case? Because in the Anthropic case, the court found that there were also allegations that could support a finding that Anthropic had downloaded lots and lots of books from pirate websites, not for AI training, but to create what it referred to as a general purpose library, something it had decided it would keep and use for purposes other than AI training. And as to that use, the court said it could not find fair use, and that would have to go to trial. And this set up a scenario in which hundreds of thousands of books were potentially at issue, each one carrying a statutory damages award, maximum potential award of $150,000, which put the range of potential damages, I think if my math is right, at over $1 trillion. And therefore, Anthropic entered a settlement with the book authors, a class action settlement of $1.5 billion. That settlement was ultimately approved after an extensive amount of briefing and the court getting satisfied that it would be fair to the class. And I believe those notices have gone out and payments may have started being paid. It's roughly because of the high level of people participating, there were about 450,000 books at issue, and each book is being paid out at about $4,000 per, which is split in most cases 50-50 between the author and the publisher. Sorry, if you go back just in the Kadri case, there was also an allegation that Meta had downloaded from these websites, but and plaintiffs had argued that this meant the use could not be fair. The court found that the fact that Meta downloaded works from these sites didn't move the needle in terms of the fair use analysis. There was no factual dispute that all of the copies Meta downloaded were for the purpose of researching and developing and training its AI models. So, but there is a claim that remains in that case. It's proceeding because of the way in which Meta pulled down some of that material. There is an allegation that it inadvertently also distributed some of that content via BitTorrent. And so we are continuing to defend that claim. Okay, so that's the current state. Apart from those two cases, we have that whole map is advancing toward similar decisions. We've got the OpenAI case advancing toward a summary judgment briefing this fall. Similarly, cases against Apple, NVIDIA, and Google are proceeding. And the case against OpenAI involves not just book authors, but also claims by the New York Times and pertains to outputs. So we have yet to see a ruling in a case where anybody is claiming outputs are infringing. So far, the cases are on the training side, and both courts have now held that the training was fair use. Meeka?
Yeah, so we do have some clarity on the issue of training rights, and we are waiting some clarity on the issue of outputs, which we will actually touch upon it later. But on the issue of training rights, and at least in the context of text inputs, we have some clarity on what AI can learn from and some of the conditions that need to exist for that training environment to be covered by fair use. So this is sort of a summary, I guess, a practitioner's summary of what Kadri and Bart's cases are telling us. We also have another case relating to fair use, which actually found that it was not fair use, but in the context of AI, but not generative AI, coming up in the Third Circuit, and that's relating to Thomson Reuters versus Ross Intelligence. And that has to do with actually, ironically, legal research tools, but that's not really at issue here because generative AI is different. But in any case, I think some of the issues you can ask yourself is on the fair use side, was the copying done? Was that training and that input copied for transformative use? For example, taking a bunch of books to create a tool to generate an infinite combination of words through a new generative AI tool? Or was the copying done to create a competing tool, like a legal research tool, like I mentioned, that competes with Westlaw with no further transformative use? Was the initial copy purchased fair and square? Or was it torrented from some sort of pirate library? And Angela touched upon this in some of the cases. Were the copies actually and immediately used for AI training? Or did they actually sit idly in an internal corporate database for unspecified future uses. And I always thought it was ironic that the copies, the books that were used for fair use, actually they maybe did not owe some sort of training license, but the copies that sat and were not used for training and kind of sat on the training floor, but didn't kind of move up to the training floor, were actually things that they had to get a license for. And then another question is, was there evidence of infringing outputs? In both of these cases, there was no evidence of a significant amount of infringing outputs. And actually in the Cadre case, there was much talk about what kind of mitigation efforts were used. Was there adversarial prompting? Did you sort of try to make the generative AI tool engage in infringement? And were you able to make it not engage in too much substantial infringement? So I think that's going to continue to be an issue, that on the output side, it will also impact whether you have the rights to use that for fair use purposes in the training context. And honestly, more existentially, I think all the courts are really struggling with a much more existential question, which is this like the most transformative innovation ever for human creativity? Or is this like the biggest existential threat ever to human creativity? And I think at some level where you come out on that existential question can kind of impact what you might think in some of these cases.
Yeah, and I'll make one other observation, which is, both cases found that there was no right to require licensing of books content for AI training. But that doesn't mean that there aren't lots of deals being done, right? A big issue in both cases with respect to the fair use analysis was the fact that no publisher owns the rights to license all of its book authors' content for AI training. The individual authors hold those rights. Conversely, where you have publishers like a textbook publisher who typically owns the copyright interest in their catalog, or you have a large studio that owns the copyright interest in its catalog, that content can be packaged and accompanied with metadata that makes it useful for training, with provenance, with other things that lots of the developers, notwithstanding these rulings, are very willing to pay to access and use. And so we're seeing a tremendous number of those deals being done, notwithstanding this sort of emerging trend toward finding that use of text for training, even without permission, would be fair use, absent regurgitation in the outputs. So we'll move on from this topic, although happy to answer questions later.
Yeah, so we'll kind of move on to the issue that's often very critical with regards to special or visual effects artists and companies and shops. Is you spend all this money, you make all this effort, and you create this wonderful AI generated material. But can you protect it? Can you protect it in the United States? Can you protect it in other foreign jurisdictions, international jurisdictions? Well, that's the question, at least for the next couple of slides we'll be discussing, at least with the United States. Is can you protect AI generated artwork content? And it's an evolving issue right now. But for the moment, surprisingly, pure AI generated content is not protectable under copyright in the United States. And why is that? Well, we'll start with going back to the 19th century, an early Supreme Court decision, as we have here. It's dealt with a photograph, a very famous photograph taken of Oscar Wilde, which was infringed by Cerrone. He virtually just copied the entire photograph. And the issue was, Cerrone was saying, when he was lawsuit against him for infringement, was, well, there's no copyright here because a camera created the work. It was created by a machine, not created by any kind of human. Ultimately, the Supreme Court in this decision basically said that, no, it actually was a human that kind of created it, because you have a pose, you have the lighting, you have a whole bunch of other different elements, as you can see in the photograph itself, that were chosen by a human. And as a result, the work was human-made. Even though it was made through a machine, it was still made by that human who was holding that machine, that camera, to create this particular photograph. So this is one of the first instances where we have an issue that says that copyright that's human created is protected. Okay, next slide. So we move a couple hundred, more than 100 years later, we move to here in California. Our courts, our appeals courts are divvied up by different jurisdictions. Here in California, in the west coast of the United States, the Ninth Circuit is the Court of Appeals that deals with these type of court appeal cases. And here we have the case here in Naruto versus Slater back in 2018. And this case, again, was kind of interesting because David Slater, who's a British nature photographer, left his camera unattended in Indonesia. And a crescent macaque monkey basically took the camera and, unbeknownst to, I guess, the monkey itself, they did a selfie. One of the first selfies in here, what kind of monkey selfie. And ultimately what happened was that the animal rights group PETA filed a lawsuit on Naruto's behalf, seeking financial damages and an injunction to declare the monkey was the copyright owner and author of the photograph. Again, what happened in the end was the Ninth Circuit basically ruled saying, well, though the monkey probably had standing to bring the case, since the monkey was not human, it could not be the author of copyright in this particular photograph because according to the Ninth Circuit and also of the U.S. copyright law, to qualify for protectable work, you have to, under authorship, it has to be created by a human being. And not only this is from the Copyright Act statute, but it's also the U.S. Copyright Compendium, which is this large book that basically copyright examiners use to review copyright applications when they come in. So in this instance, here we go. The Ninth Circuit says, once again, reiterates that in order to have a protectable copyright, the work has to be created by a human being. Next slide.
Do you mind if I handled this case opposite Naruto? I argued against him in the district court and then also in the Ninth Circuit. I'm happy to say we prevailed because if you don't beat a monkey in court, you typically have to find another job. But in this case, the question, you're right, was whether there was human authorship, and because there was not, Naruto lacked standing to pursue the claim, and it called on that earlier precedent. And so, as silly as it was, we realized at the time, and were thinking about what this would mean in the context of AI generated work, and we were very careful to make sure that we were crafting and helping to lead the court to a decision that would determine that human authorship was required, but not define what that meant, which still is, has lived to today. And so this case, and my good friend Naruto, who never showed up in court, and for all we know was very favored having his photos published. We still see this case cited for this human authorship requirement as the courts are trying to grapple with how to apply that in the context of AI.
And interesting, ultimately in the end, PETA and Slater did reach a settlement in which money was offered to the foundation, or a contribution was offered to the foundation. So in a way, what the result that PETA wanted, they got, but they got it through a settlement and not through a.
Sorry, that's not right.
No, really?
No, no part of that is right.
Okay, I'm sorry. Then somehow I was misinformed, but I take that back. Okay, when we deal with copyright protection, there has to be a de minimis amount of artistic creativity in order to obtain copyright. You can have it through a photograph, such as the one here on the left, but again, same thing, requires some artistic contribution to take this photograph at the right time, at the lighting, the author, the human author being able to determine when's the right time to snap that picture. And then here, what you got on the right is artwork, famous artwork that may look kind of like, well, does this look like anything? It looks like there's a bunch of paint just being slapped against a wall. But again, it's the artistic aspect of where that paint splatter goes that also determines its copyrightability, because again, it was a human that determined where these paint splatters go. So that's where it has to be a certain de minimis amount of human artistic creativity or contribution to warrant copyright protection. Next slide. So in 2023, the U.S. Copyright Office offered some guidance, early guidance, as to the copyrightability of material that's generated by artificial intelligence. And in essence, as I indicated earlier, was that if it's a pure AI created material, it is not protected by copyright because it's not human created, no human authorship, right? Even though it's a human that enters a prompt into an artificial intelligence platform, prompts aren't protected by copyright, nor is the output from that prompt created by is created by a human and protectable by copyright. Now, that doesn't mean it's the end all be all, because there still could be copyright protection. But again, you have to show, or at least provide evidence to the U.S. Copyright Office of what portion of this AI intelligence created material was real human authorship. And so here we have 4 points that the U.S. Copyright Office as guidance in determining what is and is not protectable in this particular context. So there's a number of different, as we see here in the top, we have the Cerrone case, we have the Naruto case. Those weren't AI cases, but again, they set their requirement for human authorship. So what we are looking at is, again, a number of different cases have been initiated regarding AI-specific authorship type cases. The most noted is the Thaler versus Perlmutter case that had a decision back in 2283 from the DC Circuit Court. That's the DC Circuit Court out of Washington, DC. And interesting in this particular case is that Thaler is a computer scientist and created an artificial intelligence system named Creativity Machine, which autonomously generated an artwork titled A Recent Entrance to Paradise, which is the image that you see there in the lower left. Now, Thaler filed a copyright application with the U.S. Copyright Office. And again, when you file a copyright application, I don't know how many people are familiar with it, but there's a lot of information you got to provide in this application. Two bits of information you have to provide is who was the author and who was the copyright claimant. And just because you're an author of a work does not necessarily make you the copyright claimant, because knowing in this industry, everyone's heard about the term work for hire. If it's a work for hire, even though you're the author of the work, can't claim copyright protection. That goes to your employer or to whoever basically required or hired the artist to do the work. So in this particular instance, Thaler filed the copyright application and he lists Creativity Machine as the sole author and himself as the copyright claimant. So instead of having Thaler list himself as the author and the copyright claimant, he had the AI platform, the AI system that he created as the author, and he listed himself as the copyright claimant. So what happened in the end in these court cases was the court said it wasn't created by a human. You list the author as this AI, and AI was the author of the work, and so it can't be, it's not a human and can't be considered protectable by copyright. And so it went up to the DC Circuit Court, and again, the DC Circuit Court upheld the Copyright Office's rejection of this application on the grounds that it was not human. This artwork was not human created. Ultimately, they attempted to file a further appeal to the U.S. Supreme Court, and that appeal was denied on March 2nd, 2026. So the DC Circuit Appeal Court decision holds, when means that, and Thaler at this point has not established the right to be able to register this particular image as a copyright. Now, there are other attempts of entities to obtain copyright registration, and it's a little bit difficult, but it can be done. In the case of the Zara of the Dawn, as you can see there in the upper left, in that particular situation, there was a copyright registration that was issued. However, it was a disclaimer for anything that was specifically AI generated. So in this instance, the artwork was AI generated. But the text, and it's a comic book, so the text of the comic book was protected because, again, that was human created, but not the particular artwork. Then we have, again, on the upper right, the image there. That's another particular lawsuit that's been filed. That was another application that was rejected by the Copyright Office, despite Allen attempting to show at least how there was some human contribution. But again, the human contribution was mostly in the prompts as opposed to any kind of actual pen to paper type contribution. And in that instance, the Copyright Office rejected this application, and it's still ongoing. If you look at the lower
Steve,
right,
sorry, that's the only pending case in the country where a human has claimed that they actually contributed authorship to the creation of a work generated in part using Gen AI models. And the case has been fully briefed in the district court in Colorado, and we are awaiting a decision as to whether the court will find that this is entitled to copyright protection in whole or in part. So that is an important case. And the Thaler case was an easy one because there was no claim of human authorship. But in this one, Mr. Allen claims human authorship, and we should be getting a ruling soon as to whether that claim will hold up in the court, which will have the ultimate say, not the Copyright Office.
Yes,
Right.
and my understanding is that he generated like 81 different versions of it through hundreds of prompts.
Yeah.
And it claimed he had some control over the output ultimately.
in the lower left, lower right, a single piece of American cheese. Again, this was AI generated artwork that was modified with an AI process called in-painting. And when this initial application was filed, the Copyright Office asked for more information about what human contribution, what human authorship was involved in. And the copyright claimant presented a huge amount of work, a huge amount of evidence to show how all this in-painting was human authorship, along with a few other areas, and it was able to be registered. Now, again, it was registered, but these particular copyright registrations that are issued that have some involvement with AI, there's always a disclaimer. And the disclaimer says that everything's protectable except for any AI two-dimensional contributions. So you get the protection, but you get a disclaimer that says any pure AI contribution is not is exempted from this copyright registration. And then you look at the Rose Enigma, the expressive prompts. Again, the prompt for this particular work was a young cyborg woman, roses, flowers coming out of her head, photorealism, cinematic lighting, hyperrealism, 8K hyper detail, and that was the prompt. And again, there was more reworking of human contribution. So there was a registration that was issued on this particular work, but again, there was a disclaimer. And the disclaimer was for a non-human expression of the final work. So again, there are copyright registrations that are issued, but again, they all have limitations on these registrations where it deals with and it exempts anything that was purely created by AI. Next slide, please. And I think you can take over from here, right?
To say, the trick with the Copyright Office and getting protection, and because this is a huge issue, right? People need to know that if they're going to use AI, they can protect what they own. And so this is an AI generated animated short that received copyright protection. And there was lots of human input that was documented as part of the application. So a human wrote the script. Even if you couldn't own anything else, that would prevent somebody else from displaying this film, because you wouldn't be able to do that without infringing the script. They used 2D renderings of images that were generated. They also claim protection over the selection and the arrangement of how the AI outputs were placed. And then there were human performances underlying the work. So I think the trick to this, and we'll talk through some key, sort of pointers, is just because AI is being used doesn't mean that a work won't qualify for copyright protection. I was with the head of the Copyright Office last week at a Copyright Society annual meeting, and they emphasize they have registered over 6,000 works that have been created in whole or in part using AI. The trick, particularly in an audiovisual work like a film, right, is that there are many layers of copyright protection, and where you can start with human created images, sketches, text, etc., and layer that in and use AI as a tool to, further develop that, you're more likely to maximize your chances of protection. We've been talking about US law, but internationally, the circumstances are, shaping up a little differently. So in China, where we've seen a number of decisions, the Chinese courts are not hesitating to actually find protection for AI generated works. I personally think that this image is absolutely beautiful. The Chinese courts found that this completely AI generated work was protectable by copyright, and then found that it had been infringed when third parties used that image in advertisements and for their own purposes. We haven't seen that case yet. Right now in the US, I would expect that somebody sued for infringing an AI generated work would be met with an argument that that work was not copyrightable. But in China, the law is shaping up differently. And next slide, this image of an AI generated woman in China was found protectable and infringed. We have also seen in other countries, just the law developing in a different way. The Surrealist case, the set of 3 images there, this involved a different tool, but he used the Van Gogh painting A Starry Night as a reference image for a photograph that he had taken, the source image, which then created the final image on the right. And the US Copyright Office refused to register that, but the Canadian and Indian authorities did. We are also seeing some countries listed there on your screen, the UK, Ireland, Hong Kong, South Africa, etc., they recognize copyright in computer generated works under certain circumstances. How that will ultimately shape up is being determined. And we have seen the German courts refuse protection on the last slide for certain AI generated icons that are, not particularly creative.
And an interesting situation that we deal with here is there a way that some of these international entities can somehow through a backdoor get protection in the United States if they can obtain a copyright protection in their home country? Can they assert that right here in the United States in courts and in an infringement action? There's basically 2 types of questions that's asked here. Will U.S. courts defer to international law when determining whether an AI-generated work is created in a foreign jurisdiction, whether that's copyrightable? And the second question is, will plaintiffs be able to enforce international copyright judgments in the United States? With regards to the first question, the United States is a member of the Berne Convention, which is one of the oldest intellectual property international treaty around historically. And because the U.S. is a member of the Berne Convention and implemented it in the U.S. copyright laws, U.S. courts must give the same protection to foreign works as to U.S. works, and this deference to foreign copyright includes a presumption of the foreign copyright validity. Now, again, it's still a presumption. I mean, there's still a presumption of validity, which is different from a copyright being in fact valid under U.S. law. So a defendant in a copyright infringement lawsuit brought by a foreign entity and a foreign copyright rights can still challenge that copyright, determine whether it's presumptively valid here in the United States. Now,
yeah, it's a big issue. I mean, it's gonna be one that our governments have to hammer out, and it's difficult given the current administration to see much moving toward consensus then. But for copyright lawyers, there is an awful lot that needs to be harmonized because, of course, this technology knows no borders. I'll just briefly touch on the trademark issues, but I think this one is important. This is a case I'm handling for Midjourney, who has been named along with Runway, Stability AI, and DeviantArt in a case brought by visual artists for alleged copyright infringement arising out of use of their images for training. But they also have asserted a claim for trade dress infringement. So as we mentioned, copyright law does not cover art styles. That's an idea. That's something that can't be protected. So instead, they've asserted that their art styles constitute their trade dress. Now, unlike copyright, which lasts for a limited time, trade dress and trademark protection can go on indefinitely, so long as you're using it. But there's no trademark registration for any of these art styles. And so the plaintiffs are going to have to prove in the case that they actually own these. Here's the problem. Sarah Anderson is claiming that she owns the art style simple, cartoony, and often strictly in black and white. Now, I can think of a number of prominent cartoonists who have been using that quote unquote style since much longer than Sarah Anderson has been alive. Similarly, Julia Kay, who's another plaintiff in the suit, claims 3-panel black and white comics loosely inked with a thin fixed width pen. Now, that describes both her and Sarah Anderson's style and making it impossible for both of them to own that. And then Greg Grotkowski, who is quite a prominent artist who is known for, creating images for Dungeons and Dragons and Magic the Gathering. He doesn't own a copyright in any of his images, but he is claiming style protection over lavish fantasy scenes. And I think the implications for creators are potentially very significant if this case gets any traction. I don't think the law supports it. The look of a work, its aesthetic, is its function, and trademark can't extend to functional attributes. I don't think that these plaintiffs will be able to show that these art styles signify them and only them as the source, which is what they'll have to show. But you can see how the development of art and the market would seize up if individual creators could claim protection over art styles that everybody has always been free to use and build on. We wouldn't otherwise have art movements. Nobody can own dragons and fantasy scenes and comics. So this is a claim that is being asserted again as a backstop to concerns about their styles being emulated on platforms. But I think it's one that would ultimately harm the plaintiffs and creators who are asserting the claim. We've also seen a claim that's been pending now for some time against Getty by Getty Images against Stability AI, where early versions of the model were able to generate these really distorted images based on the training data, but they included the watermark for Getty Images. And the theory in these cases is that causes dilution of Getty's famous trademark and creates confusion as to whether Getty is the source of this image, which they wouldn't want to be associated with. That claim hasn't proceeded very quickly. There was some wrangling over what court it should be in. And so we don't have a substantive ruling in that case, but it's another one to watch in the space.
I would just add on the trademark front, there's also a new case by CNN against Perplexity. And in addition to a copyright infringement claim, the claim is that Perplexity is implying that they have a license situation with CNN in order to provide the summaries that they provide. So by the way, in case you thought you were getting licensed summaries from CNN, you are not, because those deals fell apart. And as a result, they actually brought more of a kind of trademark claim because it implied a false, association between CNN and Perplexity that was false.
So real quick, without this is a summary of what we've been talking about as far as the AI copyright takeaways. Human authorship is required. Prompts are not enough. What counts as enough human input? That's a big question. Practical steps: document. You may not need to submit all the documentation with the original application. You may not even have to submit it with the U.S. Copyright Office if they ask for something. You don't have to present a huge amount of evidence, but you should have it in your files so that in case there's ever an infringement action and someone starts to question what the human input is, you'll have enough documentation to submit as evidence in this case, in particular case. So these are the important factors you got to look into when you start to consider all this copyright protection for AI generated works. So we move on, finally, as we move along here, we deal with the issue of right of publicity. Right of publicity, again, it's without going into too much detail, it derives from the right of privacy. It really protects an individual's identity and reputation. It's basically the right of an individual to control and profit from their commercial value of his or her own identity. Now, in a number of states, right of publicity can be protected by statute, or it's protected by common law, which is, again, a law that's not statute-oriented. Here in California, we have essentially two. We have the common law and the statute. And in fact, the statute, the California statute, which is here at section 33.4, it's rather limited because it only protects a person's name, voice, signature, photograph, or likeness. All right. It doesn't protect an imitation voice, but the common law is more expansive because the common law will also protect a person's identity or persona, which is much broader than what's provided under the statute. But, the statutes have been, and we'll talk about a few other states as well, but the statutes in these states, since there is no national right of publicity statute going on right now, it's all based on state law. And the states are attempting to grapple with this issues of artificial intelligence and deepfakes, and they are, going back to their statutes and they're amending them to include, to add, digital representations in their statutes and their laws to at least protect people's publicity rights in this particular area. And here we have in section 33.4 that's important in this particular context, at least in California. Next slide. We have other California statutes. I think, Angela, you were going to comment on this.
Yeah. So as of January 1st, 2025, both New York and California. Oh, sorry. I think we need the next slide.
Well, that's Tennessee.
Oh, sorry. You wanted me to touch on this? I think this was yours, Steve.
Oh, okay. I thought you were going to talk about it. Okay, well, in addition to section 33.44, there are other California statutes that are involved in this particular area, namely Civil Code 1708-86 that creates a civil cause of action against anyone who either creates and intentionally shares a digitalized sexually explicit material, knowing that the depicted person didn't consent, or who shares such material they didn't create while aware that the consent was absent. So this covers audiovisual work altered through digitalization to show someone nude or appearing to engage in any kind of sexual activity that they didn't actually perform. Then we also have, and now we reach even down to our elections. So there's a specific code section in California, code section 210, that prohibits distributing material that's deceptive audio or visual media of a candidate within 60 days of an election. But again, it exempts any material that carries a clear disclosure that states this image, video, audio has been manipulated, and a candidate whose likeness appears in manipulated media distributed in violation of this section can seek injunctive relief and damages in court. Now, we know in some situations where these elections it takes time to get an injunction. It takes time to run off to get a court, even a temporary restraining order. And if you have a short election, if it's a runoff election, in some instances, there may not be enough time. But, and again, there's so many ways that this can be manipulated and dealt with. So I don't know how effective this particular code section would be, but it's still there. Again, it shows the concern that at least California has with regards to digital images, manipulated digital images used in an election cycle. Next section. Tennessee, which was one of the originators of these kind of what they call post-mortem publicity rights of celebrities. They have the Elvis Act, which they amended recently to deal with this particular issue, the deepfakes and voices and all that. And so here's an example of the statute for that. Next slide, please. New York is even involved in it now, dealing with digital replicas, and they further amended their statute a few years ago. Up until a few years ago, New York didn't even have a statute on right of publicity, and so they had this statute, and now they've amended it to deal with this particular issue of digital replicas. Next slide, please. And I think here, Angela, I think this is what you were talking about, right?
Yeah, and I'm mindful of time and we're seeing questions come in, so I want to try to be quick here. But people should know that as of the beginning of 2025, in both New York and California, there are significant restrictions around your ability to contract around somebody's digital replica rights. So in New York, any contract that allows the creation and use of a digital replica in place of an in-person performance is considered void and unenforceable if the contract doesn't contain a specific description of the intended use, unless that use is consistent with the purpose of the contract and the nature of the performance to be rendered, if it was negotiated without legal counsel or labor union. So where somebody is represented by a labor union or lawyer, this wouldn't apply. But if you're dealing with a person who is unrepresented, then your contract needs to be very clear about the nature of the use of the digital replica, or it will not be enforceable. And the same is true in California. California courts will not enforce that contract. But a digital replica, it doesn't qualify as a digital replica unless the changes, fundamentally alter the nature of the performance or appearance. And so I have talked to clients, studios and creators who are, contemplating, can I make modifications using AI to performances that have been provided by performers under contracts that sort of predate AI. And sometimes the language is very broad in terms of the rights that the copyright owner has to manipulate the content. But these laws apply even to contracts that were entered before they went into effect on January 1st, 2025. So if you are contemplating using AI to modify performances, it's always good to seek legal counsel on that. But a big question is going to be, does it fundamentally alter the nature of the performance? If it does, you may need permission for that, even if the language of the contract is otherwise very broad. We don't have federal legislation yet, but this is a digital replicas sort of proposal by the federal government that I don't know, Steve, you want to say much more about it. It's been proposed years ago, and not much action has happened on it. Whether it will ever be enacted remains to be seen. The states are where the action has
The
been.
U.S. Senate passed this No Face Act last week. Now goes to the House, but unless it's passed by the end of the year, it's going to be zeroed out. You got to start all over again. But this is the first stab at what some people would believe to be the beginning of a national, or at least a U.S. national right of publicity statute.
Or just that there is the Take It Down Act, which is federal. And while it's not a right of publicity, a federal right of publicity act, it does prohibit non-consensual intimate imagery. And it actually sets up by the FTC a registry where you can go, make complaints, and platforms are required to take this stuff down and find it. I guess we should move to the next slide.
Yeah, real quick. I mean, we won't get into detail about this, but there's, obviously SAG-AFTRA, the Actors Union, has negotiated with the studios, networks, production companies. Very important on the AI. It was re-upped recently in the new contract negotiations that was included. The basic situation as it comes down to is that for the first time, both SAG-AFTRA and the producers all agree that there's a strong preference to use human actors instead of AI generated actors. But here are different types of rights that are provided here in AI generated characters. And depending where you fall in this depends on what the consent that the actor has to do before a movie, TV show, etc. can use an AI generated image of that actor. So, but that's, again, real quick, so we can move on to the next slide.
Okay, I think I'm going to give my negative 2 minutes left to deal with my 3 slides. This slide is really to just illustrate and to the different kinds of AI generated work that we might be encountering. So our very humanness is not protected by IP necessarily, and every use is not necessarily covered by every IP law. So just starting with human likeness, when you think about deepfakes covering real life humans, the copyright actually belongs to the creator of the deepfake, which of course we talked about earlier, may or may not be copyrightable as an AI generated deepfake. But the problem with the video is not that it copies the plot line or characters or background of a well-known movie franchise. It's the problem with the video is that it depicts real life people without their permission. And I'm thinking about the Sea Dance deepfake that depicted Brad Pitt and Tom Cruise apparently fighting and yelling over Jeffrey Epstein. These are issues for right of publicity law. And then when you think about right of publicity law, we talked earlier about how a lot of state statutes aren't really updated to take into account AI law. A lot of them don't even talk about digital replicas at all. And some of them don't talk about voice. A lot of them only cover famous people. And then when we move to character is different. I'm thinking about the Midjourney case, which creates perfect replicas of Darth Vader or Yoda or Shrek. And those are movie characters. They do not depict real life people. And the problem with those images are that they are fictional characters, which actually are protected by copyright law. And they are fictional characters that movie studios, as we know, spend a lot of financial and creative effort to develop. And so there is a 3-part test for fictional characters, which I don't think we have time to get into, but happy to cover that another time. And then moving to synthetic persona, I think a lot of us have been hearing about Tilly Norwood. In fact, there's a recent interview of Tilly Norwood. I think it might have been New York Magazine. So when you think about Tilly Norwood, on the one hand, she's AI generated, which could mean she's not copyrightable. But on the other hand, the creator prompted her, like iterated on her, refined her. So she might have copyright protection under the sort of selection, arrangement, and coordination tests for copyrightability. For sure, she doesn't require any consent because she doesn't depict any real life person. So I think that synthetic persona it certainly represents an interesting case for the future of IP law in the AI space. And then I think voice is really becoming more popular. There are a lot of voice cloning tools out there, and voice sort of escapes a little bit, like copyright, full copyright protection, full right of publicity protection, full trademark protection, or full biometrics protection. And voice itself, I mean, it's one of the most human of traits, is itself not copyrightable, although the recording of your voice, you saying things, is copyrightable, but not the voice itself necessarily. And then you think about voice in the context of right of publicity law, and I mentioned earlier that not every state statute covers voice, and not every state statute covers digital replicas of voice clones. So voice sort of sits in this interesting place. And then more recently, some celebrities have started to take matters into their own hands. So thinking about Taylor Swift and Matthew McConaughey, who both registered not only trademarks for images of themselves, but also voice marks or sound marks of them saying things. And what's interesting about the voice marks in particular is that while there are voice marks for, let's say, the Tarzan yell or Homer Simpson's dough, all of those voice marks are source identifiers for the fictional show or the character that they represent. In the case of Taylor Swift and Matthew McConaughey, those voice marks are source identifiers for their own personal vocal and performing services as real life people. So we don't know, the full parameters of how much protection that's going to actually provide in this age of AI, but it's certainly an interesting area that people are starting to experiment with. And then the final point I would make is that there's been at least a dozen cases on the voice front and the biometric space where the claim is that the voice recognition technologies are violating biometrics laws by taking voice prints, without somebody's permission. And then I'm just going to add these 2 slides towards the end because I think they give a good kind of business framework to think about some of these issues. Obviously, there's a lot of litigation. Not all of it has been decided. And even when the decisions come out, there's going to be vagary, in the aftermath. So it's sort of a way to look at all that risk out there, regulatory risk, business risk, legal risk, and trying to figure out a way to assess that risk so you can mitigate that risk. Figuring out how severe that harm might be, how likelihood the risk might be. And so this kind of recalibration framework breaks down the output pipeline into kind of manageable chunks. So you can look at where did the input come from? Who was the source of the input? What are the parameters under which you receive that input? The next is what kinds of input did you get? What is the asset type? Is it a copyrighted work? Is it is it data? Is it images? Is it video? Is it voice, et cetera? What is the output that's coming out? Is it an infringing output? Is it a deep fake? Is it synthetic media? We talked a little bit about, the difference between Tilly Norwood and other things. Is it style emulation? We talked a little bit about that. And then what's the legal theory that you're sitting under? Is it a copyright claim? Could it be protected for fair use purposes? Is it a right of publicity claim? Is it trademarks? There's also secondary liability issues, which we haven't got into. There's a big Supreme Court case relating to Cox Communications around music. Over cable lines. And then finally, who's the potential target? Who are the possible defendants? And who are you in the process? Are you a developer? Are you a deployer? Are you a creator? Are you distributing it? Are you a user? And I think in this audience, you might be a little bit of all those things. And so you sort of have to piece apart what your role is, what your contribution is, and where, what part of this sort of output chain you received that input and you created that output to kind of figure out what your liability might be. And then I think we can go to the next slide to close it out. And maybe if there's still people left, we can get to Q&A. But, there's obviously different, options for all of us. We can sue, we can wait to be sued, but we can also strike a deal. And so I think some of this can be solved, or at least, we can start to move on things by contracting. And I just sort of put this into 4 buckets. Obviously, AI licensing is very complicated, but there are ways to kind of parse through the issues. And what I would say is rights parameters, like what IP is going back and forth, can use what when. The economics, obviously, what are you getting paid now and in the future under a royalty basis otherwise? And importantly, are you building in the appropriate refunds, rights retractions, and contractual outs when things go wrong? The third bucket would be future proofing. And this is where I spend a lot of time, because we all know that the future is very uncertain. But what do we own? What do they own? What can we use? What can they use? What do we want to hold them back from? What liabilities do we want to push on them? What competitive opportunities do we want to make sure they don't engage in with our IP? And then finally, risk allocation. Who gets to bear the risk for rights clearances, for IP infringement, for training data rights, for all the kinds of harms that can come out of the use of AI output and the use of these tools. So that would be my message of the day, is to think about how you can contract for this stuff so you can make sure that you're on somewhat more solid grounds, because the litigation is going to keep happening. The litigators are going to keep fighting, and there's going to be still uncertainty coming out of it. So your competitive mode is making sure that your pipeline is as clean as it can be, and that you have reduced your risk, and that you can point to things to show that you were a good actor in the scheme of things.
Fantastic. That's a lot of information, enormous amount of valuable information, and very clearly a fast-moving field. We're going to move right into Q&A. I'll ask a question, please. There are a lot of great questions in the Q&A already, but we have quite a few audience members still on. So I encourage you, if you have questions, put them in the Q&A panel. We'll try and get to as many as possible. This will also be posted on the VES website under Gen AI, so you can go back to it later and refer to any of this information. So one thing that comes up a lot that I think we talked about right before this call, Michaela brought it up, is around vendors using tools and their liability and exposure. So specifically related to, you have a vendor who's using a model with highly permissive licensing. You're using it to build tools that get used into training a workflow. The model is then found to have trained on content that infringed. What is the indemnity warranty, the tool maker, and how can the vendor side best protect themselves?
Yeah, I'm happy to take a crack at that one. So all that litigation that you saw on the map currently is directed to the developers of models. We don't have cases yet directed to those who are using and deploying models developed by others to generate content. Now, if the cases against the developers gain traction and some are found liable, we may see that shift. But for now, the focus is on the developers. And the developers have so far not been found liable for infringement in the way models are trained. What I would say to those using third-party models is, so there are indemnity provisions in the standard terms offered by the developers. Bespoke contracts are going to have stronger indemnifications, but make sure that you know what those indemnifications provide, what settings have to be in order for them to apply, what the limitations of liability and the indemnification is, because there are certain things you can do that will nullify the indemnification. If that's important, anybody bringing a tool in for production is probably going to negotiate a bespoke agreement with one of these providers. And, that's something that you're going to want to focus on, is the extent to which they're going to bear the responsibility if you are ultimately found liable. But anybody using a tool is in some sense responsible for what they intentionally do with it, right? The hard case is, what happens if I use a model to generate something and I have no reason to know that that's infringing of somebody else's rights? The easier question is, if I use a model for the purpose of generating content that copies somebody else's, I'm probably going to be liable whether I'm using an AI tool or some other tool. I'm printing something off the internet. And so those using these tools, the same rules need to apply. The uses that reach the public need to be vetted for infringement of other rights. You need to get for hiring, where you're hiring creators who are using these tools, you need to have representations about what they're creating and their rights to provide that. And so I think the world functions more or less in the same manner as it did before. It's just harder now sometimes to know whether content that is not meant for the purpose of, infringing or copying, in fact does that. And I wish I had a clear answer for you, but I think address it in contract. And one other thing, where your employees are using third-party tools under their own personal licenses for work, for your work, that potentially subjects you to the terms of service that govern their account rather than any bespoke terms that are negotiated by the studio. So it is really important to keep an open line of communication to make sure your employees and contractors know what tools are permitted and that they're using it under the right license or contract, so that you don't have this situation in which they may inadvertently subject a company to a license that was, carefully otherwise negotiated.
That's really helpful guidance. Thank you. Sarah McGurl has a few questions. I'm going to start with the first one. I think the other two were hit on a bit in the presentation, but we'll see if we can get to those later. VFX artists use machine learning tools trained on licensed data to interpolate frames, reconstruct geometry, and relight scenes, with directors, cinematographers, and VFX teams making active creative decisions throughout. Is that human-directed output protectable? So they may give notes, and those notes get translated into prompts or get actions done by a machine. But
yeah, I think it goes back to a little bit of what we were talking about earlier, like that notion that if it's fully AI generated, the Copyright Office and courts will likely take the view that a machine created it. It wasn't a work of human authorship. But we also heard that the way you arrange things, what you select to put in, how you put it in, all of those things are creative choices that we all know that people make in movies. And like Angela had said it earlier, and I've been saying, as you know, Barbara, from the beginning, movies are one of the most collaborative, creative works out there. I mean, script, performances, right? All the little pieces, the setting, et cetera, all the creative choices that are made. And so I think there is a very good argument that you can make that your selection of these pieces all together create a copyrighted work, even if you might have to disclaim some of those individual AI generated pieces.
100%.
And I mean, it may even be to the extent of correlating note taking that sits in an entirely different system related to reviews that gets associated to outputs. I think one of the things you talked about is like collecting all the information around the creation. Is a director's notes considered an input?
A director's note is still considered a prompt, and the Copyright Office has even said like prompts theoretically, like as a body of work, could be copyrightable, like written in a certain way. But having said that, they also look at prompts as instructions to a machine. And I think the key for the Copyright Office is the distinction between when you hit that button and what comes out of the generative AI tool. We don't have full control over it. You and I could put in the same prompts and come out with different outputs. And so the Copyright Office, at least for now, is saying generative AI, the human doesn't have enough control over the output to say that was authored by the human. It could be that over time, some of these tools get better at being able to give you more control. And we know a lot of CGI tools are already in that front. So we'll see what happens. But it really is about control over the output.
But again, if the script, for instance, is human authored, right? Even if individual elements of a film have been affected by AI generated content
Agreed.
or decision making, the film overall is still going to be protected by copyright, and anybody displaying or copying that film is going to be in trouble. This is not meant to discourage the use of these tools for these various kinds of augmentation, right? That these are it's another set of tools in the hands of visual effects artists to realize what is a human created work. I do think you document that it doesn't need to be painstaking. It doesn't need to be, it doesn't need to interrupt the actual creative process. But you want to document the human created elements. So if there's ever a challenge later to how the film was made, you're able to say, these are all the things that were created with humans. here's how AI was used as a tool sort of on top or for pieces, and that doesn't affect the ultimate protection.
It's summertime, so I think it's a great job for an intern. Anyway, let's go to the next question.
By and large, the entire production process gets documented as is whether AI is used or not. I think the question is around like are you audit? Yeah, I hear people who are documenting in spreadsheets every single prompt, every step of the way throughout the process so that they can ensure, that there's copyrightability at the end. And is that overkill? Is that being prudent?
In some ways, it might be easier than summarizing it. So I guess I would say that, because I know a lot of people were just like feeding the machine, just sending this stuff over to have it in there. And that's easier than me saying, okay, this is what happened today, So that maybe it's an easier way to do it.
If generative AI is used to iterate and create 20 character designs, and then an artist draws a character based on these references, but is unique and it differs from all iterative examples, is the character created by a person or created by generative AI?
I vote for person.
I do too. The original images coming out of the AI tool are not protectable because they were generated by a non-human. Nobody can own those or sue you over them. Anything you're drawing then is going to be human created.
But I would go back to that Rose Enigma case, because there was some language around like it has to be it was the perceptible human part of the thing that she drew. It had to whatever the output had to been human, like perceptible to the human eye. Right. What her added creativity was. So I think there's some language there around that copyright registration that might be useful.
It's the opposite in that case. So she started, Chris Kashtanova started with a human for her own drawing, which she got copyrighted. And then she used Stable Diffusion to modify it to the more complex image. And the Copyright Office refused to register the AI generated augmentations, but because she owned the underlying copyright to the drawing, and you couldn't reproduce the color image without infringing the underlying drawing, she was sufficiently protected. And so the question here was reversed. What happens if you use AI to ideate, and then you actually take something it gives you back and modify that and draw your characters? I think so long as what you are putting into what you're drawing is your original expression, that should be a human created work, even if you started with some ideas that came from AI. So I think we all agree.
Human. Trouble, call Angela. How does copyright and trademark law of buildings like Empire State Building or the Flatiron Building impact the use of these in generative AI work, so known buildings?
Well, it's interesting talking about the Berne Convention that I mentioned earlier in the session. There was an amendment to the implementing act to the Copyright Act that dealt with architectural works, and in that instance, it was determined that certain architectural works past a certain old works like the Empire State Building were exempt from copyright protection under these architectural works because they were already somewhat in the public domain. So depending on what the building is, like old building, like the Chrysler Building, the Empire State Building, those are exempt from copyright protection. And the same thing with trademark law. Again, trademark law means that if you're using someone's trademark as a trademark to sell products, right, as opposed to just putting it in a film, right? If it just appears in a film in a cityscape, it's not being used as a trademark. And so in that context, there's no trademark, there wouldn't be any kind of trademark issue because it's what they call a descriptive use or a non-trademark use. And even though, for instance, the Empire State Building as an architectural work is not protected by copyright, the Empire State Building, the people who own it, they own a trademark registration for the image of the Empire State. But just because they have a registration doesn't mean they can assert it for anyone who's using it in a non-trademark manner. And there's been a number of cases, even pre-AI, where architectural images are used in movies and they claim trademark infringement. The party claims trademark infringement, and then it's determined that it's a non-trademark use, and therefore it's not a trademark infringement matter.
I think one warning would be not to use it necessarily in advertising.
Correct. Product, and that sort of thing.
Or product placement type stuff.
But, just in general, using it, there shouldn't be any particular problem. Now, again, any more modern buildings that would be protected as architectural works, that's a different kind of situation. But again, the cases, this is nothing new. There's been court cases going back for decades that really do not provide any liability if you're using these particular architectural images in motion pictures and other types of content.
Okay, great. I'm going to try and get to as many of these as I can. I know we just have a few more minutes. In a scenario where a studio hires a VFX vendor and requests the use of AI, where does the liability lie if there is a claim against the resulting work? I think you sort of answered this, but maybe quickly you can reiterate.
Well, real quick, I mean, this comes down to Meeka's point, which is contracting is going to be key, right? I think you want reps and warranties with respect to how that vendor is going to perform the work and what sort of checks they're going to make on the content that they're providing, and a provision that covers who's responsible in case there's a lawsuit over that content.
My big point will be, remember, getting a license does not mean they have all rights.
All right. Gosh, we have some really big questions here. We might have to try and answer some of these after the fact, but I'll go for it. What are the legal implications of platforms like YouTube hosting AI-generated videos and potentially using those videos to train video models like VO when the videos were originally created by AI models that may have been trained on copyrighted materials like the snake eating it?
So, this is a question of both copyright law and contract. So anybody who posts content to YouTube is, of course, agreeing to the terms of YouTube, which include provisions on what Google can do with the content produced, posted there. To the extent that AI generated videos were posted there that are infringing of somebody else's work, the original author may have a claim against the user of the YouTube, the person who posted the content for copyright infringement. And Google may be subject to a request to take that content down because under the Digital Millennium Copyright Act, this third-party posted content is allegedly infringing. Now, whether Google could be held liable for training on that material, I think that is a stretch. That content would be even one step further removed from training on the original work. And so to the extent the fair use decisions that we've seen so far hold, I think the same defense would apply to training on that content. And it's even more innocent, right? It would have no way of knowing that it was potentially infringing.
I would also just point out that on user-generated content, YouTube has different terms and conditions than some of the other ones do. In YouTube, when you post some of your videos up, you give a license to everyone who gets on YouTube to be able to use that, access that video and use that video. And YouTube also gets that license. So they're in a different situation than, for example, X might have different terms and conditions. And by the way, the buried language often says, we can use your content to improve our tools and products and services. And that's where they take the position that they have the right to use your content for AI training purposes. And I have seen that clause in a number of different agreements, including audiobook agreements with book authors.
Yeah, but I think the question was, so that takes care of potential liability as between Google and the party that posted the content. What about the person who claims that posted content, right, that video being posted by the user intentionally infringes their own content? They're not a YouTube user. They never agreed to abide by those terms. Again, that person may have a claim against the person who posts the video. And I think Google would have protection under the Digital Millennium Copyright Act safe harbor if it takes that content down when made aware of it.
Thank you so much. Okay, we are at the end of our overtime. I'm just going to ask the speakers to please stay online, and thanks everyone else for joining in today.